Okay, the last one of the three, and that is the judiciary. And in this presentation, we're also going to look at who is this and what are they doing, but we're also going to add the dimension of the constitutional concept of judicial independence, which informs everything that the judiciary does. And then obviously, the flip side of that coin is judicial accountability, and we're going to look at that as well. So, first of all, the independence of the judiciary, but obviously I'll run you through the composition as well. And then remember, the main task of the court is to resolve disputes through the application of law. That's the function, and to uphold the Constitution. So bear that in mind in relation to powers, but let's look at, first of all, the background. You will recall our discussion regarding the certification judgment, and particularly the drafting of the Constitution of 1996, that was guided by the 34 principles in Schedule 4 of the interim Constitution. Now, Principle 6 provided for separation of powers. So we knew that we had to have a judiciary as one of our governmental branches. Item 9, Principle 9 rather, provided for supremacy of the Constitution. So we knew we had a need for someone, some body, some institution to uphold the supremacy of the Constitution. And then Principle 7 provided for the judiciary to be personed or peopled by appropriately qualified members, and that there was a need for constitutionally ensuring that the judiciary would be independent, and we'll look at what this means, and that there was furthermore a directive that the judiciary would have the power of judicial review in the fullest sense. In other words, the power to consider the constitutionality of legislation for procedure and for substance. So, Chapter 8 of the Constitution includes the provision that the courts are independent and subject to the Constitution and the law, which they will uphold without fear, favour and prejudice. So we see compliance with Principle 7 here. And we also see that the independence of the Constitution, or the independence of the courts rather, is constitutionally secured. And just as an aside here, bear in mind that Chapter 8 is that chapter of the Constitution that deals with the judiciary, but we cannot read this in isolation, and particularly Section 34 is relevant in this regard because it provides for the right of access to court. But what is important for our purposes here is to bear in mind that we are talking about disputes that are capable of being resolved by the application of law. Some disputes simply aren't. And we have to figure out which are those disputes that may be resolved through the application of law, and which court is then appropriate to deal with it. And that is Section 166, providing for the different courts. And then please go through that again for yourself. And then 173, providing for the inherent jurisdiction of courts at the higher level, that is the High Court, the Supreme Court of Appeal, and the Constitutional Court. And that is to protect the integrity of these courts by allowing them to manage their own processes in the interest of justice. Now, returning then to composition and who makes up these courts, the courts are made up of judges, but magistrates are also part of the judiciary, and this is a significant change that was introduced in terms of the Constitution. Magistrates used to be civil servants, now they are members of the judiciary. Now, I want you to go through these sections regarding the appointment of judges, and perhaps it would be interesting for you to compare or look at this in the light of the recent Judicial Service Commission interviews that were held and the recommendations for appointment. Now, the Judicial Service Commission brings together members of the judiciary, members of civil society appointed by the President, members of the legislature, and members of the legal fraternity, in an attempt to take away some of the mystery or some of the sinister energy that may, or sinister intentions rather, that may be inferred from the appointment of judges. Judges, because they can, or they have the authority to declare legislation unconstitutional, they hold a very powerful position. And if it is indeed so, or if there is a perception that this is some just simply a question of people are being appointed because they have friends in the right places, then obviously the entire integrity of the system is being undermined. Therefore, in the modern era, the majority of members of the judiciary are appointed wherever in the world through this process that involves vetting by a commission of sorts like ours, where you bring members of the executive, the judiciary, the legislature, the civil society, the profession together. You bring them in a room and you set the potential judges up before them, and they question them and they make recommendations, and the president then ultimately appoints the person. But in the South African instance, what is significant and what is noteworthy is that the composition, and it's a fairly large commission, the composition is such that elected members, so in other words, people serving in a party political capacity as members of the NA, NCOP, or as members of the executive, still dominate this body. So if there were a political agenda, it could be pursued. But whether that is the case, I think, would depend on quite a significant amount of empirical research and investigation to be completed before one could make that inference. But the problem is not immune from political interference or political involvement. Interference is perhaps too harsh a word. And perhaps it is also more attuned to the reality that very often when judges make pronouncements, these have political implications. So look at the appointment of judges and think for yourself whether you think, as in days of yonder, where purely the executive made a decision, I like X and therefore I will appoint X. And now this process that is more open and more subject to scrutiny, whether that is something that meets the standard. Or in some states of the United States of America, people vote for judges. But I think you will agree with me that were we to go that route, that keeping people's favor or carrying favor will be far more of an issue than it is currently for judges. So judges can only be removed in very, very restricted circumstances. Judges can't be removed because they give judgments against the executive or because they do something that people don't like. And I will say something about the judicial discipline when we talk about judicial accountability in due course. Judges, in terms of Section 176, serve for life. A judge doesn't retire, just steps down from active service, and they are remunerated from public funds, and this is channeled through the Office of the Chief Justice. Until fairly recently, it was channeled through the Department of Justice and Constitutional Development, but now the Office of the Chief Justice is assuming a much more significant role. And perhaps you can think about that symbolic, if nothing else, step that was taken with the setting up of this institution to say that we govern our own things. Because when it comes to judicial independence, what is important is not only what is the reality, but also what is the perception. And then judges' salary may not be docked, and they have security of tenure, because otherwise it will be so much more easy for a member of the public or a member of a particular institution to try and influence judges to make judgments in their favor. You can look at the appointment, the terms of service and how long they serve and when they are removed. But I think the important thing for me is that you bear in mind that security of tenure is important because judges need to be independent and they need to be seen to be independent. And judges, while they don't earn as much as a senior counsel probably in private practice would earn, I think they're not really struggling, between 1 and 2 million. I think for an ordinary judge, I stand corrected as to the exact figures. But the point of the matter is you never go down to 75% of that because you always receive a full salary. Also impacting potentially on judicial independence is the whole issue of judicial training. And as with teachers, people assume that a good advocate or a good attorney would necessarily make a good judge, and that's not necessarily the case. So the South African Judicial Training Institute was established in 2009, and this body will take over and manage, and it has already started its work to deal with all the training of judges. And this is very controversial, or training of judges used to be fairly controversial, because judges are saying, if you're trying to train us on something, you're trying to indoctrinate us, and the essence of our job requires us to be independent. So through this institute, training for judges will be run by judges, and there will be an infrastructure to support that, but the principle of judicial independence will be central to this. Okay, then what we have to bear in mind when we're talking about separation of powers is, about the judiciary in general, and judicial independence is separation of powers. And that when we talk about a supreme constitution and upholding a supreme constitution, we have to bear in mind that in doing that, there has to be some sort of a balance struck between judges being proactive and judges giving meaning to the Constitution, and judges respecting and deferring to the other branches of government. So, for example, that judges don't try to take over the task of the executive or the task of the legislature, but that they respect the ability of those branches to perform their functions appropriately and within the bounds of the Constitution. So we strive for a balance between deference and activism, and hope that we strike the right chord in protecting and upholding the Constitution. But it's always a difficult one. And remember the last thing that I've said, not all disputes are capable of being resolved through law. And particularly in South Africa, what we've seen over the last couple of years is this idea that every dispute can be resolved through the application of law. And unfortunately, this is not the case. This is not true, because courts have significant authority, but sometimes the solution to a problem is political. And the proverbial smoke-filled room where politicians give and take and add and subtract and come to an agreement is something that we perhaps should learn to explore again. It really helped us in the 1990s, and perhaps we should go back to that point where not everything is dealt with in terms of the court. I mean, even political parties very often manage their affairs entirely through the courts. And one would think that the political mastery or the political ability to deal with that kind of conflict should be enhanced and developed in anyone who would like to pursue a career in politics. Okay, now the very important concept of judicial independence. Now, in a modern society, I think, and this is something that we've said over and over and over and over again, we value the protection of human rights, and we value that in a Bill of Rights, in a Supreme Constitution, these rights are specially protected and given special protection, and then that we ensure compliance with these standards in courts of law. Now, a court does not have a police force or a defense force or an army. And a court does not have the power of the purse. The court does not manage the budget. And as I'm saying this now, I realize with the previous two podcasts I forgot to mention, a very important task of the executive is to initiate how the budget of the country will be managed in Parliament, and it's done through legislation. Now, the courts do not control the budgets. The courts do not control the police. The elected branches of government are responsible for those tasks. So the court has a very difficult task of upholding and protecting the Constitution, but with what in their arsenal, with what to uphold and support them in performing their task. That's on the one hand. And then on the other hand, how do we keep courts accountable? How do we protect ourselves from rogue judges who try to take over each and every governmental function? How do we ensure independence, but we don't get rid of accountability completely? Now, the power of the courts, and if you look at the Muhammad article that I have prescribed for you from the SLJ, you will see that Judge Muhammad said that the power of the courts lie in its independence and in the integrity and the esteem in which it is held in the minds of the public. He says that no politician will dare defy the order of a court, which is and is perceived to be the true to the Constitution and the values entrenched in the Constitution. And he says that is where the power of the courts are, in their independence, their integrity, and their esteem. So, what is judicial independence then, in short? In short, it is the freedom of judicial officials to make judicial decisions free from interference by anyone and guided by the facts of the case and the law applicable. So without any interference, without any compromise, without any ideas being planted in your mind as to how you have to decide the matter, you listen to the facts, you listen to the arguments, and you decide this is it. You make a judgment according to the law and in accordance with the law that reflects the constitutional standard. That is judicial independence in a nutshell. Now, Judge Muhammad also very helpfully then teased out different aspects. He said, how do we maintain, how do we secure judicial independence? What is necessary? What are the preconditions or the hallmarks of an independent judiciary? And the first one is a subjective aspect that lies with each and every judicial officer, and that is the aspect of an absence of bias. This is the state of mind subjectively on the part of the judicial officer. And it is the responsibility of judges to not be aligned to any of the parties who are before them. So the judicial officer must act with integrity and judicial temper, and must not be overly sympathetic with plaintiff or defendant or applicant or respondent, but listen to the facts and make a decision based on the facts and the law, without any other biases, prejudices, religious, racial, cultural, language, whatever the case may be. All of those must play no role in the mind of the judicial officer. And the only way in which one could probably, as a judicial officer, secure this for yourself is to know yourself and to know what is it that makes you tick. What is it that pushes your buttons? And this aspect could thus also be referred to as impartiality. So judges must bear in mind they wield significant power. They can declare legislation unconstitutional, and they cannot bring their baggage, their personal issues with them to the bench. Having said that, it is impossible for any of us to be completely 100% objective and not invested in any particular cause. But it is important for judges to not rely on that predisposed or preconceived ideas when they make their judgments. Now, in the Safu case, the court was confronted with an application for recusal. And it was quite interesting. Louis Late, who at the time was the president of Safu, said that everyone, or the judges of the Constitutional Court, were served there after they were appointed by President Mandela, and they were thus biased in his favor, even though there was this whole Judicial Service Commission process involved as well. In paragraph 48 of the Safu judgment, the court says it's not only whether the person has bias, the judicial officer, but also the perception of bias. So the court says the question in relation to a recusal then is whether a reasonable, objective and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case, that is, a mind open to persuasion by the evidence and the submissions of counsel. So that is a very important aspect relating to impartiality. It's not only actual impartiality, but also perceptions of impartiality. And judges are constrained in this regard by their integrity and judicial temper, by their conscience, and by precedent. On a more objective aspect, or a more objective aim or objective aspect is the infrastructural independence of judges. And this relates to a whole lot of safeguards that are in place constitutionally to ensure judicial independence. And this relates to the appointment procedure, the fact that there's security of tenure, the fact that people are adequately paid, that they will not be held liable when they call a witness a liar, for example, and that they have adequate support. So the infrastructure, what are the means in place, the structures in place to ensure that a judge can do his or her job properly? And the first one relates to the appointment, and that is, as I've said to you, through the role of the Judicial Service Commission, involving all the branches of government, civil society, the professions, to try and make this as accountable and as transparent as is possible. Security of tenure, you cannot be fired for making a judgment against someone. There's a common law privilege that would protect judges where he acted, or a judge where he acted without malice in performance of his functions. The judge says the witness is a liar. If I call someone a liar, that person can sue me for defamation. But if a judge does that, the person is protected. The judge is protected from civil pursuit in a civil court of a claim against him. And then library resources, administrative support, and then with this we also count judicial training and education. And as I've explained to you, this used to be very controversial, but more and more is accepted as the norm, that one may be a good advocate, but that doesn't necessarily make you a good judge. Or you may be a good attorney, but you don't know how to be a good judge. And it is a question of perhaps just opening your mind as a potential judicial candidate and considering what you can actually learn at the Institute. And the idea was also that the Institute would run courses for potential candidates for the judiciary. And then there's the third aspect, also a more objective aspect identified by Judge Muhammad, and that is institutional independence. And he says that this requires one to put procedures in place to correct incorrect decisions. And this is where you have an appeal or a review procedure. Where something has gone wrong, as part and parcel of securing judicial independence, there must be a process for you to take your case to a higher court. And then he also says that judges have an obligation to make the law understandable and to demystify the law to enhance access to justice and access to the courts. And then that there must be sensitivity to public needs, in other words, courtesy, to give judgments on time, and so forth. But please read the article, and when you are asked, what does judicial independence mean? Start with that concise definition that it's freedom from interference from anyone, giving a judgment in accordance with the law and based on the facts, and then set out the aspects. Absence of bias, institutional and infrastructural, and flesh that out. But I want you to also go and look at the cases. I want you to go and look at the Southfield case. I want you to look at Van Rooyen in relation to magistrates' courts. I want you to look at Beinart, and I want you to look at the Modderklip case, simply for giving effect to 1654, where the court in Modderklip emphasized the importance of other branches supporting the courts in performing their duties. I'm not going to say too much about this, but I want you to bear in mind that independence of the judiciary, which goes with separation of powers, to ensure that the check of judicial review works, that goes for all courts. The High Courts, the Magistrates' Court, I've just referred you to the Van Rooyen case, and then traditional courts, and that's something which I think has been a sticky point in finalizing the legislation. Because at the current point in time, the people who staff these courts, the people who preside in traditional courts, are also members of the executive. And how do you then deal with separation of powers, judicial independence in this context where there's a conflation of roles? And that goes to De Lange versus Smuts, which we've discussed in class last week. Okay, now judicial accountability is the flip side of the coin. Who makes sure that judges behave themselves? That judges are honest, that they are not influenced by external factors, and so forth. Now, counter-majoritarianism has given rise to this great point of discussion in the modern era, and that is of judicial accountability. We entrust judges with immense power. We say, well, you can undo what the people want. The people may want the death penalty, but you can tell us, no, you can't have it. The people may want X, and you can say, no, you can't have it. But how do we curb that? How do we manage that? And one of the ways is through ensuring judicial accountability through judicial discipline. And I want you to go and look particularly at judicial discipline in this context and understand it in this context. And the Constitution specifically says that judicial discipline may be dealt with in terms of legislation. And in 2008, the Judicial Service Commission Amendment Act was passed, providing for amendment to the Act to make judicial discipline a reality. Prior to that, there was the constitutional provision, and really, judges didn't really have to face the music if they went off the rails. So now this new system provides for a code of ethics in the first instance. So judges know exactly what is expected of me, and judges must submit the gifts that they've received and all their income and the investments and everything into a register on an annual basis. And then, in addition to that, this the system of rules is backed up by a tiered system of dealing with complaints. So you, first of all, if you have a problem with the application of the law, your issue is dealt with in terms of an appeal. But if you have an issue with how the judge conducted the trial, that the judge was biased, that the judge wanted a bribe or something like that, that's when you invoke judicial discipline. So, first of all, there's a subcommittee of the Judicial Service Commission that would receive complaints. And the subcommittee would then investigate, and if necessary, the subcommittee would escalate higher, and ultimately there would be a tribunal that will run a case effectively against the judge. And then the tribunal, if the tribunal says, well, this guy is too much, we have to get rid of him, the tribunal will then make a recommendation to the National Assembly. The National Assembly will take a decision. The President will then remove the person from office as a judge, and the person will receive no benefits. So, interestingly enough, when we talk about judicial discipline, all those political members of the Judicial Service Commission are not there. And I think the reasoning behind this is simply to ensure that this is not a political game or a political tool to manipulate judges who say or take a political stance through their judgments, but it's rather when a judge misconstrues his or her powers, or when a judge really is outside the bounds of what is judicially permissible, accepting a bribe, trying to influence a colleague, that one would deal with this structure where you first have a complaint. If it's regarded at the committee stage that it's not necessary to pursue it any further, it gets stopped. And I can refer you to earlier in this week or last week, there was an announcement in the press that the committee, so in other words, first tier complaint body, said that the complaint that Judge Traversa was mean and horrible to the prosecution and very kind to the defense in the Dewani matter, that was dismissed as having no base. But please read around the concept of judicial discipline, and importantly understand how it ties in with counter-majoritarianism. So I think ultimately what one tries to do is you try, as a judiciary, as a state, as a polity, you try to find a balance between an ability on the part of the judiciary to not sit back and wait, but to uphold and protect the Constitution fiercely through its independence, but also to recognize when it's not your job. To recognize that in some instances, this is a political problem that must be resolved politically. And judges try to fulfill this very challenging task, this tightrope that they have to walk, guided by the code of ethics, taking into consideration training, and then the absence of bias, the institutional and the infrastructural independence. In relation to the appointment of judges, I would like to just flag one other matter, and that is Justice Alliance of South Africa versus President of South Africa regarding the appointment of the CJ. I think it's a very important case, just once again illustrating the importance of judicial independence and how it can be breached in a variety of ways. Okay, thanks.